There's one big exception here that is really important that we get that information out, at least in the state of Washington, is if you want to protect assets for your spouse when you are gone, and this is against long-term care costs so that they qualify for any government benefits to pay for their future long-term care, you must do so through your will. You cannot use a revocable living trust to protect assets for your surviving spouse when you're gone, because Medicaid won't honor any kind of trust that your revocable living trust created for your spouse. It feels like form over substance here, and perhaps it is, but it is very clear. Let's say that you and your spouse want to make sure you provide for each other, and like the majority of people who are older, you're concerned about long-term care costs. If that is your concern, that you want to make sure you provide for your spouse and that they would never become impoverished because they'll never have to spend down all of their money on long-term care costs, you have to use a will. You cannot use a revocable living trust. The will has within it a special kind of trust. It's that discretionary trust I was talking about. It's an asset protection trust. It's sometimes called a supplemental needs trust. And how it works is that both spouses have a will, and in the will has this trust. When the first spouse dies, their share of the couple's estate then funds this supplemental needs trust for the surviving spouse. All the assets in that trust do not count if that surviving spouse ever wants to apply for Medicaid. So let me give you an example. Let's say the couple has $1 million. First spouse dies. $500,000, the first spouse's share of this estate, we're in Washington, community property, is going to go into the trust for the surviving spouse. When that surviving spouse needs care and they apply for Medicaid, Medicaid won't count that $500,000 that's in that supplemental needs trust. What that means is that the state, when the surviving spouse is at the standard to qualify for eligibility, which is frankly only $2,000, when they are at that level, they can have the state pay for their care. The state allows $500,000 to be in this trust, and it doesn't interfere with eligibility. That money is there to support the surviving spouse in whatever care they need, but the cost of care will be paid for by the state, and the state will not have any rights to recovery from any of that money that's in the trust. And what that means is that money will go wherever the couple wanted it to go when that second spouse dies, and it will not go to the state. One of the most important tools we have to protect assets for couples against long-term care costs in the state of Washington is the will with the supplemental needs trust in it.